criminal defense attorney, Neil Rockheim.
Hey everyone, I'm Neil Rockheim. I'm a trial lawyer and criminal defense lawyer here in suburban Detroit, Michigan. I've been called the Rockweiler because of my unique courtroom style, and I love trial lawyers. Trial lawyers are among America's last great storytellers, and we're on the front line fighting the powers that be day in and day out. People started calling my cross-examination style killer cross-examination, and soon after writing about it and talking about it, we started this podcast to bring to you stories from the trenches, tips on examination, criminal justice, and legal issues. And I've really been privileged as of late to bring to you some of America's best trial lawyers so that you can hear from them. I know people love to tune into CSI or Law and Order or Dateline or any documentary like that on Netflix or Hulu. But the lawyers that you would see on those shows and the lawyers that you would hear talking about their cases are lawyers that are appearing on this podcast. We want to entertain you, but I also want you to get more justice in the legal system and more justice in your own lives. And I want you to have a chance to hear from these lawyers that have won some incredible cases and still battle on behalf of their clients in court. And today's guest has tried and won cases on national television, is frequently seen on television news shows as a legal analyst. Mark O'Mara is my guest. Like me, Mark was a state's attorney or a prosecutor for several years before venturing into private practice. He defends people accused of crime. He's involved in marital and family law, civil rights cases, attempting to right police abuse and police abuse of power, and complex and mass tort cases, which means cases in which the act of a corporation or an entity has hurt a lot of people over a wide range of a long range of time. Perhaps Mark's most noteworthy case, and I'm sure he's been asked about this only about 1 million times, was his defense of George Zimmerman, who was charged and acquitted in the death of Trayvon Martin. Mark's won just about every award you can win. And I started to try to make a list here, and I actually got tired. And I thought I would end up having to make this list. This list would just take me all of the show to pay him his appropriate due. But he's won, I think, Lawyer of the Year. He's on boards. He's the chairman of trial lawyers organizations. I think he's sought after to speak at a variety of organizations. He teaches cross-examination and cross-examination of experts. But something that I think is worth ending this probably too long introduction for Mark is his beginning of a project called Justice Outreach, which was designed to identify and fix problems in the justice system. And he's an advocate for juvenile justice. And Lord knows over the years, we've seen a pendulum, I think, Mark, of people trying to get tough on crime and taking juveniles away with it. So I appreciate your appearing with me. It's great to meet you.
It's great to meet you.
And I'm sorry that I'm in this. I'll begin in a rather humble spot. I'm sorry that you're dressed in a suit and tie, and here I am in this, black T-shirt.
No. I get a lot more work done, like I said, with the tie not wrapped around my neck. But I was in a few Zoom hearings today, so the tie went on with the jacket and sort of stayed there.
So, Mark, I want to, if you will, I'd like to kind of give people some background as to how you got to this point in your career where you're considered one of the noteworthy luminary trial lawyers in the United States. So where did your career begin?
Well, I started after law school with the state attorney's office in Seminole County. I will tell you that before that, when I was in law school, my plan, just because I was an intern with a PI firm in Orlando back when I was in college, my plan was to go with a PI firm because, quite honestly, they fought, but they were also sort of successful. They had their, not that it matters much now, they had their own plane. They had all this stuff going on. I just remember the frills of practicing law, which back when I started, you don't know what practicing law really is. You just looked for people who wore nice suits or drove nice cars or had their own plane. But when a buddy of mine went to do an internship with the state attorney's office, and I actually watched him in the courtroom as a law student, I got bit. And there was no question in my world anymore that I was going to do trial law. And trial law, as you know, Neil, means starting out as either a public defender or a state attorney. I literally, when I was there for 2.5 years or so, I think I left with something like 67 or 68 jury trials. That is unheard of. Well, today it's almost unheard of anyway. But back then, the civil practitioners who I looked up to when I was an intern in college, they had 20, 25 trials under their belt, and I walked out in 2.5 years with double or triple that. So, well, I was bit hard by the bug when I watched a buddy of mine, and then doing criminal defense work or criminal prosecution, I just realized that there was no other place to get to in a courtroom as much as doing some criminal work.
What was the thing that drew you in when you first watched your friend in court, where you said to yourself, not only do I want to do that, and I'm going to do that, but I'm going to be great at that?
Well, I didn't know I was going to be great. I will share my first trial as a prosecutor, and I swear this is true. I'm up there as a prosecutor. I remember the case. Metheny was the name of the case. And I was prosecuting a woman for a battery. And I'm up there not knowing what I'm doing because it's literally my first trial. I'm sort of directing witnesses. I'm sort of crossing witnesses. And I'm doing my closing argument. You know, the reason we all went to law school was to do a closing argument. And I'm literally talking about the case. And I point back at the defendant. And I went, and it was at that point that misses. And I blanked on the defendant's name. And no, I'm sorry. And I blanked on the victim's name. I said, at that point, when defendant Smith, Metheny, struck, and I blanked out, and an older woman in the front of the jury panel looked up at me and said, Mrs. Brown, and told me the victim's name. It was like, all right, I got to go out and get a new profession because I just blew this one.
That's great.
But really, what really got me both with Joe Flood was his name, the guy who I went to see when he was doing his internship, and those first couple of years of prosecuting, was it really is not just the amazing drama of a courtroom, and just the idea of living in that sort of stage of doing it, but doing it on behalf of the Constitution. Now, as a prosecutor, I felt I was defending the Constitution, because I knew what justice was and who needed to be prosecuted and who needed to be given a bit of a break. And so there was a real focus on justice. Obviously, as a criminal defense attorney, I really feel that we defend the Constitution because it's those rights that we all have that criminal defendants get the benefit of in a trial setting, that we're really protecting the rights of the Constitution that the rest of us get to enjoy every day.
Interesting you say that, because I had a trial where I was really trying to find a theme, and the theme was really a trial, like a real trial. And so the theme was that the system has to work first for the worst. It has to work first for the worst cases, the worst people, the worst crimes.
Yeah.
Can't work in a case involving a trespassing if it doesn't work in the worst case.
Oh, absolutely. Yeah. And we, you know, when I get on my high horse, sometimes people ask me what I do. I say, I train prosecutors. Oh, are you a prosecutor yourself? No, I train prosecutors how to get their convictions, because I show them where they make their mistakes. I show them that they haven't proven their case beyond a reasonable doubt, right? And that is really what good criminal defense attorneys do.
Right.
And when I, you know, I really get on a high horse, I say, well, look, I make sure that you can wander through your life not worried about things like whether or not you're going to get stopped by a cop for no reason, whether or not your car is going to get searched without a good reason, whether or not you're going to get arrested and thrown in jail without somebody there by your side, because that's what criminal defense attorneys do. We train cops and prosecutors to do their jobs perfectly, or they don't get to arrest you, or they certainly don't get to prosecute.
Hey, Mark, you have an interesting story about, I guess, sort of the impetus, or maybe, I don't know if it was your final case, but it was near you're nodding, so you know what I'm talking about. It was either your final case or it was one of your final cases that motivated you to leave the prosecutor's office.
Yeah.
Would you tell us about that? I think you know what I'm talking about.
Well, I will tell you, this is when you're talking about where the young Black girl was charged with murder. So I was a prosecutor,
Yes.
and this young 16-year-old black girl was pregnant and had her child in a bedroom. Nobody knew about it. She was a very heavy-set woman, young girl. Had the baby, let the baby die. And of course, it was found out. Sheriff's office decided to bring charges against her. So they were trying to sort of teach a lesson to a female prosecutor who was not paying enough attention to the sheriff's office. They dropping the cases and not doing whatever. Called for her, she wasn't around. Lo and behold, I come, ta-da, I take over. And they actually had, the lesson was that they were going to have her sit through the autopsy of this infant. So great, I get to sit through the autopsy of this infant. And then they go and figure out a way to talk to this 16-year-old about what's going on and keep her away from her mom and dad, and get a confession from her, and intend to use that confession to prove up, yes, you knew it was a baby, of course, yes, you knew the baby was alive, yes, you knew the baby would die if not for blah, blah, blah. And literally got this confession from this 16-year-old who had just had a child, who wasn't particularly bright. She had some mental health difficulties. And they got this confession, and now I, as the prosecutor, am supposed to, in effect, uphold the validity of this and to, you know, carry the flag that we now have this confession of basically first-degree murder from the 16-year-old. And I wouldn't do it. I ended up reaching out to the public defender who was assigned to the case and told him, he's now a judge, as a matter of fact, and told him this is what was going on, and it was not a good confession. And they ended up not charging her as an adult like they wanted to, not charging with first-degree murder as they wanted to, and dealt with her in juvenile court like they should have. And then
what was the institutional reaction that you felt from that, from handing that information over to the defense lawyer, which clearly changed the trajectory of that case?
Well, no, it was, I was shown the door, pretty much. I was not going to progress in the system. I was not going to progress at the state attorney's office, which, by the way, I still loved doing back then. And it was pretty much a game changer and a career ender in that sense, because the person who found out about it, and I wasn't hidden about it, I was upfront with it, just did not think that was the way to handle the case, and that I gave up what I shouldn't have given up. But I will sleep pretty soundly at night knowing that in that case, the right thing happened, because, you know, justice was served, and it was not right for the cops to do what they did to that 16-year-old.
Mark, I think that's a great story. And one day there's going to be a group of former prosecutors that like do a huge, almost like a web project where we all share our departure stories, or the case the day before we left, you know, the cases that sort of were our impetus for leaving. How would you, so, I'm going to ask you about the Zimmerman, Trayvon Martin case, of course. I want to fast forward a bit, if I could, kind of looking back. How would you describe your style of lawyering?
That's tough. First of all, I'm a collaborative lawyer. I try and get things figured out, and whatever we can do to resolve the case. And remember, most people don't get this, but we all know in the system, 95% of these cases, whatever, work themselves through without going to trial, which means, they may have been charged with too much, they may have been charged with too little, a prosecutor will add more. But what we do sort of is damage control for the criminal justice system. We look at a case, somebody comes to my office and say, this is what happened. And we, like I said earlier, we make sure that if the state is going to have a case, they have to do everything right. We know as criminal defense lawyers that our obligation in a courtroom, we could literally fall asleep at the defense table for what we are required to offer to the prosecution, right? We don't have to do anything. The prosecution has to present the witnesses, compel what they want to present to a jury, and convince that jury beyond a reasonable doubt, without us doing anything, that they have proven their case. Now, obviously, good defense lawyers do the cross-examination to show the weaknesses and everything else that we do, including on occasion, present our own witnesses on behalf of the defense, and even on fewer occasions, have our own defendant, our own client present testimony. but that's sort of what we have to do. So my thought is always try and work through what you can with the prosecutor. But if that doesn't work, and if the client wants or the state demands, then we try cases. Now, if I can wake up every day of my life, pick up a file, walk into a courtroom and try a case, that's my nirvana. That is what I didn't realize it when I was 10 or 12 or 15 or 20, but I was created to be a trial lawyer. I just am so happy that I found my course the way that I did, because I am never any more comfortable anywhere else than in a courtroom trying a case. Because at that point, it is that whole sort of three-dimensional chess game of working with all of the actors, most importantly, your only audience that counts, the jury, but all of the actors involved to present your client, your case, your presentation as best you can to that audience. And I love it.
I guess, are you, so look, for example, I interviewed Jeff Lichtman, who is sort of the classic New York brawler.
Yeah.
I said, "What's your style?" He goes, "Smothering."
Right.
I want to smother him from the moment I stand up to the moment I sit down.
Yeah.
I interviewed F. Lee Bailey too, and Lee was more like, well, I kind of try to feel him out, and then when I see an opening, I go for it. So, like, for example, some of the concepts that you talked about,
Right.
how do you bring reasonable doubt to life? How do you get the jurors to get in touch with it as opposed to just an abstract concept?
Well, a couple of ways. First of all, I think, and most people, I get frustrated because I actually teach lawyers how to do jury selection and how to bring that in jury selection, how to bring in anything from reasonable doubt to implicit biases and whatnot. And I think if you're a good lawyer in jury selection, and really get the jury to understand what this process is, because don't forget, jurors have no idea what's going on when they walk into particularly a criminal courtroom. Civil courtroom, you know, that beyond a read, that preponderance, maybe they get a feel for that because they do that in most of their lives. In a criminal courtroom, they have no idea what a beyond a reasonable doubt standard is, and they default back to what they know, which is, don't worry about it, we'll figure it out, put on your evidence. I have common sense and I'll decide because I've decided for the first 20, 30, 40, 50 years of my life. But if you can get them to understand the very unique nature that we live in a criminal courtroom, that of beyond a reasonable doubt, meaning 100 people are supposed to go free before we convict one improperly, tough concept for people to accept. But if we get them used to that concept, that the idea that a beyond a reasonable doubt standard is only that which you will use in your most important decisions and all the other, analogies that we make in a criminal courtroom for beyond a reasonable doubt. If you can get them started there, get them used to that, then that's sort of the premise from which they will view your case. So that's the seed of what a reasonable doubt is.
You put it to jurors like that, Mark? Do you put it to them that saying about have you heard the saying, is it better to let a 100 guilty men go free than to convict one innocent person?
I think it's difficult to say that to a jury. I don't say it like that, but because you walk in and go, hey, look, my guy's guilty, but you should let him go. That's the way that's going to be heard. You don't want to do that. But what you do want to do is get across to the jury that they have probably never used the beyond a reasonable doubt standard before in their life. And I will ask them, I'll say, hey, what about, your most significant decisions? What are they? Take a job, buy a house, get married, have kids, change jobs, move, right? You sort of start walking them through that. And then you say, well, okay, I got that. So when you bought a house, were you considering 2 or 3 other houses? Well, yeah, of course. So now all of a sudden, it's really not a beyond a reasonable doubt. I was certain when you made the decision because you were compromising along the way. Bigger backyard, double car garage, or whatever. Getting married even, you get, and again, you have to have the right juror to take them down this path, but you have a juror who's sitting there going, well, yeah, I decided to get married. I love it forever. Did you decide when to get married? Were you in college or out of college? Did you ever date anybody else? You can, if you get them, talking a little bit, then you can really show them what the standard is. But more importantly, and I don't want to just rant on because I can chat about this stuff.
You're not ranting at all. This is, to me, it's fascinating stuff. So
What I love doing, and this is what I sort of train lawyers on as well. So when you, particularly in a criminal courtroom, the hierarchy is very well known. Judge way at the top, and who's beyond it? Well, those are the clerks, right? They're next because they're high up too, and they're there to help, and they're there to help the judge. So, and I say this, if you want to lose a jury before you ever start talking to them, walk up to the clerk when you're, you're busy, you're a lawyer, you got a lot going on. Take a piece of paper and toss it to the clerk. I have blah, 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 file that. You're done, right? Because 60 people back there are looking at the arrogant lawyer who they don't really like lawyers to begin with. The reason why we normally have dinner with other lawyers is because regular people won't eat with us. So if you really want to upset that juror before you ever talk to them, disrespect somebody in the courtroom, throw something at a clerk, fail to even acknowledge a court reporter or a bailiff or a court deputy, right? Because they're watching to figure out what's going on. And remember, judge, clerks, then the bailiffs or court deputies, then the prosecutor, because they represent the state, then maybe you, if you're lucky, and then your defendant client down the road. So what I say is that if you can maintain if you can be a guide, if you can maintain your own credibility, look, this is the system that we're in. The prosecutor gets up there and says, hey, can you be fair? Yeah. Can you be impartial? Yeah. Can you convict this guy? Yeah. And then they sit down. But if you go in there as a defense attorney and explain what's going on, and how unique it is, but how much we rely on them, subtly, you're becoming sort of their guide. And if I can rant for like a couple minutes, I've got a phenomenal Zimmerman story to tell you.
yeah, I would love to hear it, because I actually, when I have given talks, have told lawyers that being a trial lawyer actually starts as you're driving and pulling into the parking lot. I've said, so when you're pulling into the parking lot, and of course we're here in the Motor City, but when you're pulling into the parking lot, the person, now you may be in a hurry and you want to get your trial bag and you want to, make sure that you have your last sip of coffee, and you don't want coffee on your, your nice white shirt or your tie. But as you're zipping into the parking lot, trying to get there so the judge doesn't yell at you because, they hear the footsteps in the hallway, the person who you may have cut off, or may be tailgating, or may, be cursing at, could be a juror, and you would never know it.
Right. Absolutely.
So, all right, tie this into Zimmerman. I'm dying because I'm
okay. So
we lawyers are supposed to be good at segues, and you just gave us the great segue to the Zimmerman trial.
All right. Well, here's your segue, because I did not plan this, but talking about trying to be a guide. So we're talking about reasonable doubt when we're in the general jury selection. It's like 70 or 80 jurors, and we're talking them all before we start doing individual. And I start going into reasonable doubt because you have 15 to 20 minutes, you got to talk about it, bring them in. And now the panel they're being interactive, which is great. And you love an interactive jury because you get Mr. Smith talk to Ms. Jones, and then Jones says something. So well, Mr. Brown, what do you think about what Mr. Smith said? And you get them interacting back and forth, and you're sort of as the almost conductor. Life is good. And Neil, you know this. Life is just going well because now they're talking about reasonable doubt, which is what you want. So I get them going back and forth, and I get the judge, because you can't do this and get turned down, but I get the judge to read the reasonable doubt instruction to them because they have questions. Well, I'm not supposed to tell you what reasonable doubt is, but maybe Judge Nelson will. And now all of a sudden the judge is telling them what reasonable doubt is in the middle of jury selection, which is phenomenal. So I go on for like 15 to 20 minutes and 25 minutes. And now I know I'm at the edge. I got other stuff to talk about, and I'm about done. And this lady in the back raises her hand, and this is all on tape, so I'm not making this up. In the back, and I'm going, I was sort of done. But okay, yes, Miss Smith. And she goes, Mr. O'Mara, I just wanted to say that, when we started this, I really wasn't sure what this reasonable doubt was because I've never heard of it before. And I was really trying to figure it out, but I just want to thank you for having, spent the time to explain it to us in a way that really makes sense to me. And this is literally in the panel of 60 people in the Zimmerman case, being broadcast. And I'm sitting there going, okay, well, we're done here. I mean, what do you say that this juror in front of 60 other jurors is thanking me for helping clear up this reasonable doubt? And again, not just patting myself in the back, that stuff.
No, you go home and you put some money in your my booby used to call it a pishka box. You put it in there to,
Yeah,
which is like a Yiddish thing to give something, pay it forward.
pay it forward.
Because someone tapped her on the shoulder and said, help Mr. O'Meara out, because she obviously did.
Absolutely. And what that, sort of crystallized was the idea of being able to be a guide to the jury, of being able to sit back and go, yes, I'm representing him, but this is the brand new system, reasonable doubt, a cross-examination, a direct examination, or burden of proof, or presumption of innocence. You start getting them listening to you as though you are not like he was saying, not just a, smother you to death kind of guy, because we have to have that in our, back belt as well. When we need to smother a witness, we have to be able to. But if you can actually get out there and have these jurors get that you're trying to help them through it, then they'll listen to you more. And that's what counts in this game, is credibility.
Tell me a little bit about, walk me through, first of all, because I want to ask some questions about the Zimmerman case itself. But I know since that time, I read that you had taken on the representation of the family of Adrian Green. Are you still involved in that case, or?
Yeah, as a matter of fact, next Wednesday is his 1-year anniversary. We're going to have a balloon release on that. Still trying to get something done. We're not going to, because quite honestly, the state attorney has sort of made their decision, and it's difficult to override a sitting prosecutor's decision not to prosecute, but we're still trying.
For those who don't know, will you tell us a little bit about the sad case of Adrian Green and how he died?
It's just, it's unfortunately, it's one of 100 stories this in the past year, right? I mean, this used to be unheard of, or at least it used to be unreported. But Adrian Green, young guy, 17-year-old black kid, strange, the juxtaposing with Trayvon Martin. This happened a mile and a half away from the Trayvon Martin killing, just coincidentally.
Same city.
It's same city, Sanford, Florida. So my guy, Adrian, of course he's passed, about this, the story, may have been trying to break into a car. I'm not gonna, gloss over it. We seem to walk through a fence. We're seeing if the car was open. Homeowner hears something, calls 911. So he's on 911. They're coming. He's announced somebody's maybe in my front yard. He goes out and steps out with a gun and shoots, again, on the phone with police, shoots Adrian in the back and kills him because he was breaking into his car. Now, technically, under Florida law and most, is he on the curtilage? It's a law school exam question. Is he on the curtilage? Yes. Was he trying to break in the house? Absolutely not. Were they safe inside the house? Absolutely yes. Was he armed? The homeowner? Yes. Was Adrian? Absolutely not. But yet Adrian, at 17 years of age, is shot and killed for breaking into a car. And the whole idea was, why? Why'd you kill this young black kid? Yes, he was breaking into your car, frustrating, but generally speaking, we still put life, car, it's up here somewhere. It's not the other way around. So Adrian's family came to me to try and help out and try and convince the state attorney to file charges. And they said no, because of curtilage. He's on the property, technically like being in the house, which you and I know on a law school exam question. Sure, out there in the real world, please, come on, don't shoot somebody for that. And now he's dead, and nothing's going to happen, it looks like, even with our efforts.
So I mentioned that case because I imagine that that case came to you in the aftermath of the Zimmerman acquittal. And I don't want people to think that because you represented George Zimmerman, that somehow you've aligned yourself with like the far right, anti, the pro blue line, whatever the current, terminology is.
Yeah.
Is that fair for me to say that you have not?
No, it's very fair. And it's funny because, people have now said, first of all, how dare you represent him? And it's like, well, that's sort of like a guy, a doctor in the ER going, well, I don't like the fact that you smoke cigarettes or that you're a little overweight, so I'm not going to operate on you. criminal defense lawyers serve a purpose. We represent people who may have done something wrong, they may not have, but we're supposed to give them our best efforts. So I say to those people who say, how dare you? Well, why don't you do me a favor and look at my pedigree? 35 years of doing this. Look back over the past 35 years and see how many young Black males, as an example of the demographic, that I have represented and helped out. And when I really get frustrated, I go, so I tell you what, why don't we just compare how many young Black males' lives I have helped out or saved compared to whatever it is you do. And you're complaining to me about representing one who did kill a young Black male. If you really want to get frustrated at me, I represented one of Orange County's first official serial killers. He killed somewhere between 7 and 11 women up and down the I-4 corridor. We don't know how many because they didn't find them all. But if you really want to get frustrated at me for using my talents for somebody, maybe that's the one to be frustrated on, not the guy who was charged with an offense, seemingly for at least partially political reasons. But go ahead and look at my pedigree. So it is a little bit frustrating, but no, I am not on the right-wing side of life. I say that I belong to the rationalist party, not the Republican or Democrat. It's got to make sense, and I'll probably follow the lead on something like that. But probably one of the best stories was only 2 or 3 weeks after the Zimmerman verdict, I got a call from somebody who was shot by the police for having stolen a sandwich. Sean Grant was his name. And they found he was in the hospital because they shot him in the face and in the arm, but he survived. And it was funny because they wanted me to come see them with him still in the hospital, and I did. And no joke, I walked in the room. This is 3 or 4 weeks after verdict. I walked in the room, and it was a Black family. And it just sort of caught me by surprise a little bit, because there had still been quite a lot of blowback from the Black community that George was acquitted for the death of Trayvon. And but it was sort of surprising to me that they were still willing to reach out or trust me with their sons at that point in life. But it's what I've done for 35
Right,
years.
of course.
Yeah.
Let me ask you a little bit about the experience, the Zimmerman case.
Yeah.
So first of all, there were deeply intense fault lines in that case. And public sentiment against your client was really was palpable.
Oh, yeah.
How did you, and he did not come across, at least from my view, having represented some clients that are difficult clients or may not carry, that may be a public pariah. How did you deal with that? How did you deal with a difficult client like that?
Well, it's hard to parse out everything from the negative publicity. There was some danger. I mean, we had a lot of calls, but we had about 2,500 legitimate threats on us that Department of Homeland Security and the Sheriff's Office had to look into and sort of vet through. The problem with it is you don't know if it's somebody in Kansas in his mother's back bedroom with a borrowed laptop and a bathrobe, blah blah blah, or if it's somebody down the street with a 9mm. So you got to be careful about that. I didn't know when we first got the case, it was starting to blow up. It was right when the day that he got charged with second-degree murder.
What made you take it, Mark? What convinced you to take the case?
The first time I was asked that was that night. They said, well, why did you take this case? And I didn't think about it. I said, it's because it's what I do.
Mm-hmm.
But it really is the best answer, Neil. You know it. It's what we do. You come to
I
me,
understand.
somebody, someone's saying I did this or I did this, and we go, okay, well, this is what I do. And literally that was why. It wasn't this. Here's what happened. I got the phone call, and I called my wife first because I knew it was going to be work. I didn't know how much work it turned out to be. No regrets at all, but it was going to be work, and it was already public. So I called Jen first, got sort of her okay, because she really wouldn't say no, but it's always good to ask your wife. And then I talked to my staff because I knew it was going to be a lot of work for them. I wasn't talking about the danger of it yet, but I was just talking about the workload and the craziness. But then
when a case like that comes in, what goes through your mind? Do you immediately, as you're meeting, are Are you looking at jury instructions? Are you getting to meet the client and getting a feel for him? Are you immediately starting to figure out what you'll do and how the case is defensible or not? Walk me through that process for you.
Yeah, I mean, it's almost, I don't want to say autopilot, but it's like I use doctor's analogies a lot. It's like a doctor looking at, a compound fracture. You know what to do, but for 4 or 5 or 10%, right? Good lawyers look at it and go, okay, cocaine possession, this, or bad search, or bad confession, or, bad prior record. And you sort of get a good feel. In that case, the publicity was growing, so we knew we were going to have to be careful about that, not aggressive, and we sort of got a bit aggressive. Well, we got affirmative, but we knew we had to deal with that. And I thought we had this, big bulldog client, 300-pound client with the orange jacket that they had on in his one of his pictures. And then we thought we had this little 12 or 13-year-old Trayvon Martin, which was the picture that had been floated around with the Hollister t-shirt. So I knew that was going to be a lot to deal with. Bizarre how when I first met George, I literally, no exaggeration, thought I walked into the wrong cell, because there was this guy sitting like, crouched in, nothing like the picture that I had. And, you think I would know better.
How big or how diminutive was he at the time?
So when I saw, he was about 180 pounds, what is he, about 5'9", 180 pounds, which is not big. And when you compare the picture of him, because both the picture of him, 2005, about 5 years before, he was about 285, 300 pounds. And he just looked like a bulldog. Fast forward to the trial, he had gained about 135 pounds. So by the time he got to trial, he was about 300 or 290. So much so that we had to figure out, and there was some tactics we did along the way in trial, how to get across to the jury, this is not the guy who got into the fight with Trayvon. The guy who got into the fight with Trayvon was weighing 140 pounds less, which was really a bizarre, we had to address that in strange ways. If we had 5 hours, we'd get into it.
How did you do that?
Well, I mean, I'll tell you, we didn't, I really did not want George to testify. He would not have been a good witness. I thank God for the state screwing up by putting on his 5 statements, because it took away the need for him to testify. But I'll tell you a couple of the ways we did it. We had some pictures of him that night. I actually had a silhouette made of that picture, a life-size silhouette. Then I had a life-size silhouette of Trayvon made. And I was able to show that Trayvon is about my height. I'm about 6'2", 6'3". He's about 6'1". I think he was 170 pounds or so. I'm about 190 now. But there was a comparison. So a couple of times I brought George up, didn't testify, but I had him help me with some demonstrative. So I had George literally help me with the silhouette. So now live person is picking up the silhouette of back then George, and you can see physically the massive difference between the two, the silhouette and him. Totally unspoken to the jury, but obvious. And then I did some other stuff about me walking up to a 5'11" witness. I had him step down because we had a picture of 5'11" witness and Trayvon a little taller. It was the 7-Eleven clerk. So I was able to show that as well to get that comparison out, because to show the size of Trayvon, and sort of presented George to the jury as the very, very overweight person that he was, as compared to the 185 or 180 person that he was the night of the event.
A couple of things that I want to ask you about in that case. You could obviously spend hours upon hours talking about the case, but tell me how you ended up dividing up the work between you and, I think it was your colleague Don West, was that?
Yes.
And I have to ask about the joke that he told to begin his opening.
Yeah.
So it was a knock joke. And could you walk me through that? How did you divide up the work, and what about that joke?
So so I was sort of lead counsel because I had the case first. And let me tell you, Don, if I ever got in trouble, Don West would be the first call that I made. I think he is a penultimate trial lawyer. Having said that, Don was not on his best game during that trial because he was so improperly but utterly frustrated with the prosecution, who again, I say, and come to me if they want to, the most unethical group of people I've ever defended a case against. Horrific what they were doing to us, intentionally running us down rabbit holes for discovery, but whatever. And that really—
You guys were taking like depositions at night and over on the weekends. You were doing like last minute discovery. For those that are listening who don't know that, I mean, the idea is the defense is supposed to have all of that before the trial. You're not supposed to get waylaid with that during the trial.
No, they hid discovery from us. I'll give you an example. Trayvon's phone was in evidence. They never disclosed it to us. We literally went down to FDLE, which is where evidence was, to look at all the evidence. And we could spend hours on this. So I literally are looking at the tables where they have evidence spread out, and I see a bag that has a cell phone in it. And I went, whoa, whose phone? That was on Trayvon Martin. It doesn't work. And move on. And I went, well, wait a minute. Has anyone, what do you mean it doesn't work? Well, it got wet because the ground was wet and it doesn't work. I went, okay, this is like a year later or 10 months later. I went, and it's dead. I went, does anyone have a charger? Now, this is Florida Department of Law Enforcement. One would think they have a charger. A half hour later, they find a charger because we're not letting up. They plug it in and the phone works. That's
lo and behold.
Yeah,
right.
What a surprise. So we then spend the next couple of months trying to get the information off of it because of cell phones with passcode on it. We get it. We finally get it to an organization out in California who can get it. They get it open, and now the state gives us what's called a BIN file, which is literally ones and zeros. It's a binary file. You can do absolutely nothing with it. It is ones and zeros. Making us go out and do all these hoops and giving us only after we fight for it, we actually get some of what's called a Cellbrite. It's a Cellbrite download, but it's only partial. It was literally, we are now on the eve of trial that we're finally getting this discovery in Trayvon's cell phone that had a lot of information on it that was very, very relevant. A lot we just decided not to use, but I'm sorry, I went on a rant.
No. We were talking about, it's totally fine. We were talking about Don was frustrated with the way that they were, the opponents, the prosecutors were handling discovery.
And also the way the judge didn't hold them to task, because Judge Nelson was trying her best, but these prosecutors were getting away with stuff they shouldn't have. So anyway, so the way we sort of split it up, I'm going to do closing. I mean, that's like, whoever can decide to do closing is going to do it. So I was doing closing, and I was going to do George's direct, because we thought at that point he might still have to testify. I had no thought that the state was going to, give us the gift of putting in his statements for us. So I was going to do that, and then I had picked out some of the witnesses that I want to do, some of the experts. So it was easy.
Can I explain this for 1 second, just so people who aren't lawyers? Mark is talking about there are some very peculiar rules of evidence that actually say that a prior witness's statement or it's hearsay for an out-of-court statement to be admitted in court. We all know that. When the defendant, the accused, makes statements to the police or to other people, there are some prosecutors that put all of that in because they want to point out contradictions or variances in the story, or they believe in fundamental fairness. There are other prosecutors that try to a little gamesmanship, and they hold that back. And they say, we're not going to put in anything that the defendant says. And if we try to get it in, we say, what did he tell you? And we get an objection to hearsay. And basically their statement, they're conveying the message to Mark or someone like me, which is, if you want George Zimmerman you want his statements to the police or his story in, he's going to have to testify to it. So when a prosecutor puts all those statements in, they're giving you the opportunity to hear your client's voice without having to subject him to cross-examination. Is that?
Yeah, that's exactly what happened. And I don't think they wanted to do it. I think as the case progressed, and as, again, tapping myself on the back a little bit, as we were turning their state witnesses into defense witnesses, all of the cops who testified and all of that, I think they realized they don't have, their case is starting to fall apart, so that they had to put in the statement. You know, there were some inconsistencies, there were some quote admissions, there were some things that he said he did. So, you know, they wanted to put it in, including, of course, the infamous Sean Hannity interview, which really frustrated the hell out of me. But anyway, so yeah, once they put all of that in, then, you know, we were given this gift because we did not have to do the one thing that defense attorneys hate to do, which is to put your client on the stand.
So Mark, tell me about the joke. So was that planned?
No. Well, so here's what happened. If you remember, so the state gets on there and they have to go with the emotions of the moment, right? The first few words that the prosecutor, John Guy, put in is he screams out the words, effing punks, effing punks. I mean, that's his first two words of his opening. You know, and what he's doing is he's parroting what George said in a non-911 call, where he says, you know, blah, 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 effing punks always get away with this. I mean, it was almost under his breath. And there's John, effing punks, you know, with a drum roll. And so Don, I think, thought, you know, and then the emotions and the emotions and the emotions, because the prosecution was not going to get their conviction for second degree or anything unless they dragged emotions into the moment, right? Poor, you know, Trayvon killed for no reason, emotions. And that was their theory. That was their philosophy of the case. And I think Don decided last minute, as it was, to sort of break the thread and to almost break the ice. So, and because his plan was he was going to go through it very methodically, which he did after the joke. You know, we have this, we have this, we have this, we have this, we have this. And I think that he thought just a little levity, a little humor, and again, Don is such a better lawyer than this, but it just, of the moment, you know, you get that trial hypnosis sometimes. And I think he thought, go in there and lighten the mood by saying, I think the joke was like, you know, knock, knock, who's there? George Zimmerman who? Great, you don't know George Zimmerman, you're a perfect juror.
You're on the jury, right?
You're on the jury. And literally, he said that, and just, you know, everybody in the courtroom, you know.
Still to this day, when I think about it, I hear the silence of that after that. What was your reaction? What did you think?
It's nationally televised, and the family of the decedent is there, and it was just, and the jury, you know, if the jury had, I suppose that if there was a joke to be told, and the jury said, oh, yeah, you know, then okay, but you know, the jury's reaction was like, don't know what that means, and/or did you just call us ignorant because we don't know George Zimmerman, or, you know, so there was a real frustration about that.
Yeah.
You know, but the intent was, I think, to sort of change the let's call it, change the moment.
Yeah, to empty out the air, and to, you walk into I mean, I totally get it. It's like you ever walked into a yoga class and you walk in there from the class before and it's like, oh, you know what I mean? And you know what I mean? You don't realize as you're walking out that that's the air that you've left, but it's like gross. And so you're trying to sort of clear the air out. And I totally get it. It was just an awkward moment.
It was because it seemed insensitive to what was going on, though it was certainly not intended.
Of course not. But so have you had any moments like that yourself, Mark, when you look back at it, you think to yourself, how could I have said that? Or how could I have, I mean, obviously we talked a moment ago about you as a prosecutor in your first trial and you forgot the complaining witness's name, but have you had any moments like that in big cases where you sort of step in it and you're thinking, how do I kind of clean off my shoe if it's possible?
Oh yeah, no. You know, again, I mentioned trial hypnosis. I'm sure you've suffered from it as well. I know I do a lot. You know,
we call it defense delirium.
Yeah, right. You think you're in the zone and you're just sitting there going, and then you're realizing I'm impressing the hell out of myself. But those people over there on the jury, they're sitting there going, what are you prancing around the courtroom for? Well, I will give you an example of something that I did which I still have second thoughts about, but I've now decided I should not have done it in the Zimmerman case. And that is when Miss Sabrina Fulton, was put on the stand by the state. This is the mom of Trayvon, put on the stand by the state. Now, they didn't just do it as you're the mom of Trayvon, so let's get some sympathy out there. They did it on the factual determination of, yes, that's my son's voice, because that was the issue. Yeah, I'll finish this and I'll go back to something if I might. So when they were done with her, it's now up to me, do I cross-examine mom of Trayvon? And I decided to. And it was not the right, there was no reason to do that. Was there a moment of reason to do it at the moment I decided to do it? Sure. Looking back, should I have just let a mom of a 17-year-old who had passed just get back off the stand? Without question. And as I'm up
When
there,
you were, so let me take you to that moment.
Yeah.
As you're questioning her, is it dawning on you that this is not a good idea, or is it only after the fact when you sat down and thought, that was something that if I could do again, I wouldn't?
No, I think it was during the time that I was there. I knew it was during the time, because I started, and I try to be very respectful. And what also sort of ticked me off is I started by saying, I'm very sorry for your loss. And of course, the state objects. Seriously.
Objection. He's got to ask questions, Your Honor.
Yeah, whatever. Fine. So whatever. And then I go in because I got to talk to her about the fact that, of course you would hear your son. Anything other than hearing your son, other than it being your son's voice, means that, he was part of his own death. As I'm saying those questions, I'm sitting there going, sit down, dude. You do not need to be here. What are you doing? You got 6 people over there. They're all women. And you are talking to the mom who lost her son last year. Who in God's name do you think you are? And what are you accomplishing here besides pissing them all off?
And it's frustrating. It's when you're litigating, you're putting yourself on trial for being up there questioning her. In the meantime, you need all of your wits about you just to figure out how to extricate yourself from that.
Okay.
So I've had moments like that where I'm up there and I'm sitting there and I'm thinking to myself, like, what are you doing? Why are you doing it? I'm not saying this out loud, am I? Oh my God, how do I recover from that? How do I make a graceful exit? How do I sit down? And then it's you're very raw when you're up there.
Oh yeah, I'm very exposed.
And this wasn't just your normal case where, everybody's looking at you in the courtroom. This is a case where everybody's looking at you basically everywhere in the world.
Oh yeah, and that evening, 50 or 100, across the networks were going to parse through every question that we posed, because everybody had to have an opinion on everything we asked.
Do you read the news in the middle of that case, Mark, or in the middle of your cases?
No, I really didn't. We had some staff, we had some interns that were helping sort of keep track. There was a bizarre part to that Zimmerman case, which is we had our own Twitter account. Totally bizarre. We had our own Facebook page. And the reason why we had the Twitter account was there was such a flood of information that was flowing through the internet and therefore in traditional media that we had to try and stick our finger in a little bit to see what was going on. So we did have some interns going through that to see what we had to respond to and if we would respond. So that was a bizarre part of that case as well.
What was your favorite? So I know there was the cross-exam, or it was really your redirect examination of, I think one of the eyewitnesses with the state had attempted to use like a blow-up doll or a dummy to make a point, and you really turned that on its head. And I don't know if you thought that was a defining moment in the trial, but walk me through that if you could.
Okay, so I have 2. So cut me off, or I'm going to tell you the second one as well. The one you're talking about was John Guy was up there and using the doll. I think he called it Bendy was the name of this doll, which is an anatomically correct sized doll where you can move the arms and the legs and they'll stay where they are. and he used it for whatever purpose. And so I'm getting up to now do, I think it was recross of a witness. Yeah, it was. And I just remember walking over to him, and the words just came out as I'm walking to go to do the recross, and I grabbed Bendy by the arm and I said, "Can I borrow your doll?" And just looked at him. There was nothing else he could say.
He knew. I mean, he had to know at that point that there was nothing good for him
No.
or the state's case after this.
So
He can't turn you down, because if he turns you down, he's the asshole,
right.
right?
Yeah. And I'm looking at the jury literally over his shoulders, because it's defense, state, jury. And I'm talking to him, looking at them, 2 or 3 of them crack a smile, and I take the doll and drag it by its arm up to where I wanted it, just like some little kid dragging a doll behind it. And then I do my getting on him and sort of jumping on him and being Trayvon and George being the doll and sort of bouncing his head off the cement, which is what did happen from all the forensic evidence.
So that was a big moment in the trial.
Yeah.
And then there was another moment. So there was 2. What was the other moment that you wanted to share?
So the other moment is Chris Serino, who is the investigating officer, the chief investigating officer. He's up there doing his direct, and I get him in cross, and we're going through all this. And literally, again, we go through all these conversations with George, because he was the chief investigating officer. And he gets to the point where he said, and he told me this. And I went, well, what do you think? And he goes, well, blah, blah, blah. And there's this thing, as you know, there's this challenge interview where you go, well, George, we have videotape. Some guy was videotaping the whole thing. What do you have to say for yourself? And normally they go, oh my God, okay, I did do this. And George's response was, thank God, I was hoping that somebody would videotape. And he's now saying this in cross-examination. And I went to, and I said, well, what does that indicate to you? And Serino says, well, either that he is a pathological liar or he's telling the truth. And I'm just sitting there going, okay, for the purpose of this question, let us is there any evidence whatsoever in all of the other statements, in everything that you said to him, in everything that he said to you, in any other evidence you got from other witnesses, which was inconsistent with what he said to you, any evidence whatsoever that he was a pathological liar? No. What does that leave? He was telling the truth. Those words came out of his mouth, and I'm standing at the podium. You know this. I'm standing at the podium. I'm looking at my notes, and I'm thinking, how long can I stand here without saying anything?
You're just letting it sink in. You're just letting it kind of take over.
The chief investigating officer just said, my guy is telling the truth. It is literally, and I'm not, again, it's all on tape, so these would be great stories if I made them up. It is like 5 minutes to 5. And I'm looking at him, and I'm just standing there going, okay. And I turn around to look at the clock, and I went, Your Honor, this may be a good time to break. And she says, it's 5 minutes to 5, we'll break for the evening. And I go sit down. And this jury, literally for the next day, overnight, the last words they heard was the chief investigating officer just said that George Zimmerman told the truth. Fast forward to the next morning, of course, the state, who's totally freaking out, files a motion to strike it from the record because, Judge, what was elicited was, evidence of the ultimate fact, the ultimate truth, and that's improper. So I'm sitting there going, I don't care what you do. I don't care what you do. I don't care if you bring in a crucifix and put him. I don't care. So now, fast forward, the jury comes in, and the court says, blah blah blah.
Judge gives the Barbara Streisand effect instruction, which is ignore what you heard yesterday. Don't think about it again. Remember when you heard that?
Yeah.
Erase it.
The same thing that I'm talking to you about again, you should not think about again. And literally, that was probably one of the finest moments of the trial, because
I mean, it's an incredible moment because, and I've done, I do television, analysis here. I know you do it all over, for major networks, but the fact of the matter is that when you can get the jury to go home at the end of the day and leave them with either a really putrid witness or a really powerful, constructive, helpful comment like that, you're going home and you're thinking that's human nature. It's in their head. I mean, that's in their head. They're ruminating about that for all night thinking, why are we here if this guy is the lead detective and he just said, I believe the guy? Like, why am I sequestered? Why am I here?
Mm-hmm. And it all fit into our overall presentation, which was subtly, they're doing this case because they want to do it, not because they should be doing it.
So, Mark, I've taken up enough of your time. I know that. I know you probably got about a million things to do, personal and professional, but I have I want to ask, I know you've got a really incredible career. What other cases are you working? I know the Zimmerman case is the one we've talked a lot about, but I know you have a ton of other cases going on. If people wanted to learn more about what you're currently doing, where would they go to learn more about the cases you're currently handling, or if they wanted just to reach out to you?
Well, reach out to the website, mark@omeralawgroup.com, call my office. I try and be available as well. I'm handling a couple of sort of interesting cases right now. We're just suing a sheriff's office locally. My guy left a Walmart after knocking over some water bottles, goes back to his car. Cops draw down on him. They put, for no reason, because it's a misdemeanor stop at worst, they tell him to stop. He goes off to his car. He tries to leave. They put 14 shots inside of his car and paralyze him from the waist down. The one cop with his 45, the other cop with an M4. Not exactly sure why you're taking an M4 to a car, but okay. And they literally paralyze him and they charge him with aggravated assault, saying that he tried to run them over. Videotape shows that he wasn't. And so now we're handling that civil rights case because, they destroyed this guy's life and put him in a wheelchair for the rest of his life. So we have that case going on right now and some other cases like that. I finished a couple of years ago, that Sam DeBose case you might have heard about, cop, very similar in one sense to what just happened with George Floyd. It wasn't 9.5 minutes, but it was a completely uncalled for killing of a black guy, basically because he was black and okay, he didn't have his front license plate on the car, but there's that going on. We have, of course, some of the mass tort work that I'm going on right now with the various drug companies whose drugs do what they do. So there's a lot. Right now, I'm sort of focusing more on the civil rights stuff because that's intriguing to me. But we just finished a case, unfortunately, where a woman in the throes of a mental health breakdown shot her son. We just sort of worked that out. Not great, but a good resolution. Dealing with another case right now with a son who was in the throes of what's called a post-ictal, a seizure event that he had and some damage he did with his mom. So, criminal cases like that. I got to say that the Zimmerman case has totally changed the practice because obviously the national publicity because of it. So what I love about that, not fallout, but benefit, is some of these cases come to me that probably would not have come to me otherwise, and I get to work on some cases that I really enjoy.
Well, that's fantastic. So, and I appreciate you sharing the positive. Obviously, an acquittal is an acquittal, but that the aftermath of the Zimmerman case for you professionally has been positive. It has exposed you to more people and expose them to you and giving you a chance to help more people, I think is what it sounds like. So last, what's your website?
It's Mark or omeralawgroup.com is the website. And then mark@omeralawgroup.com is my email. So yeah, take a look at it and give us a call. Do
you have a podcast or do you have a Twitter account or Instagram or anything like that?
The Twitter is @MarkOmeralaw. I'm active on Facebook under O'Mara Law Group, and of course my own personal one. I think I'm a public figure, whatever that is now, so I have one of those as well.
Fancy, you got a blue check.
Yeah. So anyway, we're here. Seems like 24/7, 7 days a week. I just am so happy that I really found something I love doing because it's not work. I don't want to say I'll do it for free or else I get a bunch of calls. But we like doing what we do, and love the idea of getting anyone near a courtroom.
I appreciate it. Mark O'Mara, so I'm going to leave with this, that I took a lot away from the way you conducted yourself with witnesses in that case. And I know that there's probably, I could do a whole other show about how you've been teaching lawyers to cross-examine experts and eyewitnesses. And I know you're speaking at I think it's the National Trial Lawyers, the top 100 trial lawyers. You just have so much going on. And I, as a lawyer, as a criminal defense lawyer, I very much value and appreciate how you put yourself out there in a difficult circumstance, took on a difficult case, and still have kept your head held up high and are doing even more and better things for the community around you. So, Mark, it's been a real pleasure. I mean, I mean that. And I can tell, I just want to say, I can tell your exuberance, your passion for this, because at times you stood up and you have, I ask you for an example and you want to give 2 and 3. And I think it's wonderful for young people who have an interest, or even people who are looking for lawyers, who are shopping around for lawyers, to know that there are people out there, even if you can't hire Mark O'Mara, there are people like Mark out there that have a passion for doing this and are eager to take on to get into the courtroom. Oh, yeah. So Mark, I'm gonna stop the recording. I'm gonna thank you for appearing with me. Again, this is Neil Rockheim. This is Killer Cross-Examination. You can find us on YouTube. You can find us on Twitter, on every platform, Apple, Spotify, Google. You can watch Mark and I, and you can replay this conversation over and over again if you choose to on YouTube. If you like it, subscribe to it, download it, share it, tell others about it. Because this is really, I keep telling you over and over again, folks, that when you tune into a show like Dateline to hear a segment of an hour-long interview chopped down into a couple of sentences, the lawyers that you would be listening to are guys like Mark. And it's my privilege to work in the same field as them.
Examination, a podcast by your host, the nationally renowned criminal defense attorney, Neil Rockheim.